Well, welcome to Horty Springer Health Law Expressions podcast entitled Proposed New Rule for Provider-Based Status. These rules were published in the July 7, 2026 Federal Register, and while they are proposed rules, we think that you really need to take heed of what they say because they are enacting an act of Congress, and we think that, and they're going to go into effect one way or the other. So Dan, why don't you tell us more about what these rules are and when they'll go into effect?
That's right, Henry. This was part of or an outgrowth of the Consolidated Appropriations Act of 2026, which the President signed on February 3rd, 2026. And what that section does is direct CMS to adopt regulations that will prohibit Medicare payments under the outpatient prospective payment system beginning on January 1, 2028, unless off-campus departments of the provider bill using a separate National Provider Identifier, which generally is called an NPI number, and the main provider, in this case the hospital, submits an attestation that each one of those provider-based departments meets the requirements of the provider-based rules. Now, as Henry said, that effective date is baked in by statute. So it's not that CMS is going to be able to say, well, you guys aren't ready, we'll push it to 2029 or modify the effective date. That is locked in by the statute. So what we wanted to talk about is how this affects you. And Henry, maybe you could give a brief recap on the provider-based rules, in particular, how they apply to outpatient departments of the hospital that are off campus, because that's what this rule applies to.
Yeah, the provider-based rules have been a source of controversy for many, many years. And as Dan said, what CMS would do would come out with a proposed rule, and then there were so many comments to it, and there was so much to consider that they would just keep kicking the can down the road and never adopt final rules. Well, they can't do that with this particular proposed rule because, as Dan said, it's statutorily mandated. The provider-based rules essentially state that they describe the circumstances under which a department can be considered to be part of the hospital. The importance of that is that a provider-based service gets to bill as a hospital outpatient service. So there's a technical fee and a professional fee. And what many people found over the years is that if a service that had been previously provided in a physician practice and was paid under the physician fee schedule, there was one lump sum payment that included everything related to that care. However, if you provided the same service in a provider-based department, because of the fact that there was a technical fee and a professional fee, many times there was increased Medicare reimbursement in a provider-based service for the exact same service that was provided in a physician practice. This caused a lot of consultants to say, hey, you're nuts, you're leaving money on the table if you don't provider-based a particular specialty, especially a physician practice. So what a lot of hospitals did over the years is they would buy a physician practice. Before the closing, it had billed under the Medicare fee schedule, but presto changeo, we make it a provider-based service, and all of a sudden you get to bill a technical fee and a professional fee, which often resulted in higher reimbursement, but it also resulted in the patient paying a technical copayment and deductible and a professional copayment and deductible, and it increased the cost of the Medicare program. So this was not lost on CMS and most especially not lost on Congress. So Congress has decided to take matters into its own hand and, as Dan said, passed Section 6225 of the Consolidated Appropriations Act of 2026 and mandated that as of January 1st, 2028, any off-campus, which means more than 200 yards from
250 yards from the main building
of the hospital, will need to comply with these rules as a condition of payment.
Yeah, and it's important to understand that segment of the rule, that it's only applying to off-campus departments. So if you have some provider-based offices on your campus, they wouldn't apply. And sometimes it gets rather difficult, depending on the topography of a particular hospital, to define exactly what is within 250 yards. You look at the profile of the hospital, then you go out 250 yards from that. Sometimes you can ask for an exception or a variance from the regional office if you have some unique characteristics as to where the hospital is located, but it applies to outpatient departments. Now you might think, well, wait a minute, we're fine. We've been operating these as provider-based for years. But a lot of times, unless you had a physician office in those provider-based off-campus departments, you would not have filed an attestation. You might have, and you could have, but the only requirement to file attestations were outpatient departments of hospitals that were off-campus and that housed physicians. Now, it applies to everything that's off-campus. So it might be a physician office, it might be a laboratory, it might be a diagnostic center, it might be an infusion center. So all of those things now have to have attestations filed. But before you file the attestation, you're going to have to get an MPI number. And as far as we know, most off-campus outpatient departments of hospitals just operate under the hospital's MPI number. Now, that's not the end of the world either. It takes maybe about 15 days to get an MPI number, but you have to do that first and then go through the attestation process for each and every outpatient department of the hospital that you want to have treated as provider-based or that you currently are treating as provider-based that's off campus.
And one aspect of these rules that they're not specifically addressed in the proposed regulations, but we think it's important to keep in mind is for those hospitals that are qualified for 340B drug reimbursement, you have to keep in mind that in order to be eligible for 340B, the patient has to be a hospital patient. Now, there was some recent cases that have defined that term and given it a pretty broad definition, but you still have to be a hospital patient. If you qualify for provider-based status, you're a hospital patient. But if you don't follow these rules or you don't make the attestation or you don't qualify anymore for provider-based status, then the 340B program won't reimburse medications that are dispensed out of that practice, and it can have an adverse effect on the reimbursement that the hospital has obtained in the past. Again, as Dan pointed out, the attestation was voluntary in most circumstances, not all, but most, but now it's no longer voluntary, it's mandatory. CMS is supposed to come up with a standardized attestation form, but of course, they haven't done that yet.
Well, they proposed one, but I mean, it's still, you're going to have to go back to the drawing board in each one of these.
Right, and you're going to have to use the form that they end up making final.
Yeah, usually, and what's been the case up until now is each one of the Medicare administrative contractors or MACs has their own attestation form. They all look kind of sort of alike, but part of the regulation was to say we're going to come up with an off-campus provider attestation form that's standardized across all of the MACs. So everybody has to use this. And you can access it online, and it's labeled for comment only. And it's a number of questions you go through, which you've probably done in the past if you have filed an attestation for any of your provider-based departments, where you answer yes, no, as to whether or not you meet all the requirements in 42 USC 413.65, the provider-based regulations. But remember, anytime that you have to quote unquote attest something to the hospital, if it's inaccurate, or if they find out that you misstated something on purpose, you can get in serious trouble. There could be false claims liability. There could be other penalties associated with a false attestation. So when you go through this process next year, which you probably need to start sooner than later, because January 1, 2028 is going to come around pretty quickly. And if you have a lot of different provider-based departments, or if you're in a system with a lot of hospitals that have a lot of provider-based departments that are off campus, you're going to have to make sure that each one of these meets the rules. And sometimes you may have filed an attestation years ago, and when you talk to the people operating it, you find out they never heard of the provider-based rules and aren't doing things according to Hoyle in terms of what the rules would require.
And that's important because the provider-based rules have a number of requirements that a lot of hospitals don't think about. We're going to talk about some of the issues that we want to make sure that you comply with you should be complying with them now, but you have to comply with them after January 1, 2028. Because as Dan said, you're making an attestation, and this statute that Congress passed stated that it is the condition of payment that you qualify and satisfy all the requirements of the provider-based rules, which means that if you don't, there will be false claims liability. Now, there have been false claims cases, mostly key TAMs, that have been based on the provider-based rules in the past, but they've been pretty few and far between and not necessarily very successful. But we think that after these rules go into effect, that it will be much easier to bring a key TAM claim based on a failure to comply with an aspect of the provider-based rules, because they will be made a condition of payment.
Yeah. Now, one of the Phillips, if you will, on this rule is that it doesn't apply to remote locations of the hospital or satellite hospitals, which would be basically a miniature hospital that is connected to a big hospital, still under the same CCN number as the main hospital. But it does apply to off-campus facilities that are more than 250 yards from a remote location or a satellite hospital. So if you have a couple different hospitals under the same Medicare provider number, CCN number, then if there are outpatient departments that are connected to the remote location or satellite hospital, you need to file the attestations for those too. So basically what you need to do, and put this on your tick list, is first of all, watch in November, because they're going to come out with the final OPPS, Outpatient Prospective Payment System regulations, which will include the final implementation rule for this section of the Consolidated Appropriations Act. As Henry mentioned, it's probably not going to change. It would be highly unlikely unless Congress acted, and they probably won't do anything between now and November. If Congress changed that, that's one thing, but they'll probably still be in effect, have an effective date of January 1, 2028. So you back up from that. Once you see the final rules, then you're going to have to start getting NPI numbers for each one of these locations, even if they're under the hospital's NPI number now. And an NPI number isn't that hard to get. There's a website that CMS has. It's called the MPPES website, where you can get a provider number, or an NPI number rather. And it takes about 10 to 15 days, depending on whether you're doing it online or filing a paper application. But you have to do one for each one of these entities. Again, that's the easy part, although you got to make sure you've done it for each one, because otherwise, come January 28th, they won't be eligible to get provider-based reimbursement. Then comes the harder part, which is to go through the provider-based rules and the off-campus provider-based attestation that, as I said, it's for comment only, but the final is probably going to be a lot like this, because all this does is parrot the provider-based rules for each one of those entities and make sure that they all qualify for every element of the provider-based rules. And Henry will talk about in a minute. There's a few little tricks in there that you have to watch out for that can trip you up. But part of that is not just a legal requirement, a part of it's somebody checking a box and sending a form into CMS. You got to make sure, since you're attesting under penalty of perjury and penalty of penalties, that you're going to have met all of the provisions for each one of these locations. So you have to talk to the operations people. You may have to do some on-site reviews. I mean, one of the issues is how you represent yourself to the public, what the signage says. And if these were recently acquired, or if you're in a system that maybe acquired a hospital with some provider-based departments that maybe didn't look at the level of detail that you did, you're going to have to look at all of those. And it's going to take a while to make sure you're okay before you file those attestations, which have to go in before New Year's Day of January 2028.
And as Dan said, you have to look at the provider-based rules, 42 CFR 413.65, and with in a new light, and make sure you're complying with them. There's simple things like, remember, you're part of the hospital, so you have to be part of the hospital's license, unless the state requires a different license for that particular service. You follow the state rules and CMS will agree with that. But for the most part, you have to recognize that you are a part of a department of the hospital, and you have to act like it. So you have to be under the license, again, unless a separate license is required.
Yeah, one issue about that, Henry, there's also a little variation on that theme. We recently had a hospital that had provider-based departments in another state, and that state no longer required those provider-based departments or clinical, they were clinics, they were physician clinics to have a license. So they still would be surveyed for compliance with the conditions of participation under Medicare, but they didn't have a license, and that was okay. And so those are little tricks, especially if you have provider-based entities that cross a state line.
And we have a number of clients where the doctors don't go into the hospital that much anymore. So the question is, do they need appointment? Do they need clinical privileges?
On the medical staff.
On the medical staff of the hospital. And the answer is, if they are in a provider-based service, the answer is yes. Not only do they have to have at least clinical privileges at the main provider, but they also have to be subject to the same peer review services as the main provider. And that's something that a lot of outpatient departments have not really focused on that much, especially in physician practices, is there has to be some form of peer review that's connected to the main provider over the outpatient department. You also have to have things like financial integration, public awareness. You have to identify the service as a department of the hospital. But there are some really unusual provisions in the provider-based rules that we, they are sometimes, they're not intuitive. They're just rules that you have to comply with. And we want to make sure to mention them, one of which is that the hospital outpatient department must treat all Medicare patients for billing purposes as hospital outpatient. The department must not treat some Medicare patients as hospital patients and others as physician office patients. So some people think that, oh, well, we're not utilizing this space all the time, so we'll lease it out to doctors. As long as we charge a fair market value lease, they'll pay us fair market value and they can bill it as a physician practice. You can't do that in a provider-based service. All the patients who are seen in that outpatient provider-based service must be treated as hospital patients. You can't lease space, even at fair market value basis that complies with Stark and everything else. It doesn't matter, because under the provider-based rules, you have to only utilize that space, has to be dedicated for hospital services. The other thing to keep in mind is that when a patient is seen there, it's subject to the so-called Medicare 3-day rule, which bundles, if a patient is seen in an outpatient department and then admitted to the hospital within 3 days, the service is not separately billable as an outpatient service. It has to be bundled into the inpatient admission. And then one other provision that is very unique and relatively recent is that if in a hospital outpatient off-campus department, you have to provide written notice of certain requirements to patients to let them know that they are in a hospital outpatient department, that they will be billed as such, and that they will have to pay a facility fee and a professional fee, a facility copay and a professional copay. And you also have to make them aware of other services in the area where they could obtain the same service without having to pay those particular reimbursement requirements because you're receiving it in a hospital outpatient department. These are things that should be implemented now in any hospital outpatient department, but it's really important that once these rules go into effect and you're testing that you are complying with the hospital outpatient rules, that you are complying with all of these rules, especially these odd ones that don't make a lot of sense, but they do have to be complied with.
Yeah, I mean, it's more than check the box. Just a couple other ones along that line. One is, since it's a hospital outpatient department, you cannot bill for the services of advanced practice professionals incident to the physician's services under the physician's provider number because you're in a hospital. The incident to rules only apply outside of a hospital. You could look at the split share rules. Those are in flux as well, but that's one where a lot of people trip up. Plus, there are a couple of rules that apply to off-campus departments that don't apply if you're off campus, on campus. One is you can't do these as a joint venture with anybody, whereas the provider-based rules allow joint venture services to be provider-based if they're on the hospital campus, but not off the hospital campus. And finally, you can't have the off-campus department managed by another entity. So if you had a management contract for some of these that only apply to the off-campus departments, that would mean that you didn't meet the provider-based rules. So these are just some things to think about. We wanted you to be aware of it as soon as we could get this out, because this is going to be a big job. It's going to be a heavier lift than a lot of people imagine. And unless you get ahead of these rules, if you wait until the end of 2027 to start filing attestations, you could find yourself behind the eight ball. So thanks for your attention. Hopefully this has been helpful to you. And, November of next year, Henry, is interesting. Although November of this year, we're doing a conference in Las Vegas on all these rules and anything that affects hospital physician contracts. So if you have an opportunity, check out our website and would love to see you there.
Hope to see you, and thank you for listening to this podcast.
Thank you.